Good morning, everybody. If we can come to order, welcome to this 100th annual meeting of the membership of the American branch of international law. I'm delighted to welcome you to our meeting and to our concluding day of International Law Weekend. We're going to adjust the agenda slightly to begin with an address by Mr. Justice Goldstone. And I understand that Jennifer Trahan is going to make an introduction. Professor, if you come up.
Thank you, David. Let me just do a sound check. Richard, can you hear me? And can we hear you? Richard, can you hear us? It doesn't seem so. Maddie?
Is that microphone not on anymore?
I don't think this microphone is on.
Oh, he's muted.
Okay, well, okay, but he doesn't hear me.
Talking to that.
Richard, can you hear me? Hi, folks. Good morning.
He's muted. I know.
Richard, do you hear me?
There.
Yes, okay, then can you unmute yourself? I just want to do a sound check before we start. Are you there?
Right.
Yes,
I'm
we're
here.
connected. Okay, all right. It is with great pleasure that I'm presenting the Outstanding Achievement Award of the American branch of the International Law Association to someone I consider both a friend and a mentor, Justice Richard Goldstone. The award is given to recognize outstanding contributions in the field of international law. Richard is exceedingly well deserving of this award. You most likely know Justice Goldstone from serving as the prosecutor of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. And from my perspective, I think we cannot overemphasize the importance of this work, because without the ICTY and ICTR, we don't know if we would have had any of our subsequent tribunals, including the International Criminal Court. Previous to serving as ICTY and ICTR prosecutor, Justice Goldstone chaired what became known as the Goldstone Commission, an independent judicial commission that investigated activities and people who posed a threat to the restoration of civil rights during the transition to post-apartheid South Africa. From 1995 to 2003, Justice Goldstone served on the Constitutional Court of South Africa. Additionally, he has engaged in numerous activities related to the rule of law and human rights. In 1999, he chaired the Independent International Commission on Kosovo that was established by Swedish Prime Minister Göran Persson. In 2004, he was appointed by the Secretary General of the United Nations to the Independent International Committee that investigated the Oil for Food program, and his chairmanship of the fact-finding mission on possible war crimes and international human rights violations committed by any party in the context of the military action in Gaza in December 2008 and January 2009. In 2008, he chaired a UN committee to advise the United Nations on appropriate steps to preserve the archives and legacy of the ad hoc criminal tribunals. He recently chaired the independent expert review established in December 2019 by the International Criminal Court's Assembly of State Parties to review the ICC and Rome Statute system. He is the recipient of many awards, including the MacArthur Award for International Justice, the American Bar Association's International Human Rights Award, the Richard Neustadt Award from the Kennedy School of Government at Harvard University, as well as honorary doctorates of law from universities in South Africa, Europe, North America, and Israel. He's an international member of the American Academy of Arts and Sciences, an honorary bencher of the Inner Temple London, and an honorary fellow of St. John's College, Cambridge. He is indeed also the author of For Humanity, Reflections of a War Crimes Investigator. Richard.
Jennifer, thank you very much indeed for your very generous and warm introduction. It is a great honor to receive this award, and especially at this International Law Weekend that celebrates the centenary of the American branch of the International Law Association. It is also a privilege to have been invited to make some remarks on this occasion. My only regret is that I'm not with you in person. I propose for a few minutes to consider the many ways in which my career has been shaped by contact with American lawyers, jurists, politicians, and many others, and especially with regard to the recognition and enforcement of human rights and international humanitarian law. I will conclude with a few remarks about the approach of the United States to international criminal courts. In my earliest adult years, I was impressed with the contributions that Americans had made to the recognition and enforcement of fundamental human rights at both the domestic and international levels. In my home South Africa, the American civil rights movement inspired and gave hope to countless millions of victims of repression and racial discrimination, and to those who fought against the apartheid system. As a student leader and anti-apartheid activist at the University of the Witwatersrand in Johannesburg, I had a rather dramatic introduction to the courage of a former president of the United States Student Association, Allard Lowenstein. I was then president of our University Students' Council. It was 1958. I was contacted by Allard Lowenstein, who was visiting South Africa, I thought, and apparently as a tourist. But a few days after our meeting, Lowenstein hit the headlines. Hans Bucas, a student from what is now Namibia, had been granted a scholarship by the Norwegian Students' Association. Some weeks before, as he was about to depart on a flight to Europe, his passport had been withdrawn by the South African government. Lowenstein's real purpose of his visit was to smuggle Bucas over the border, concealed in the trunk of his car. It was a very high-risk operation. It was successful. That was certainly a dramatic introduction to the United States political activism. I might mention, to complete the story, that Lowenstein became a member of the House of Representatives, and in 1980 was shot and killed in his Manhattan office by a former fellow student at Stanford University Law School. During my earliest days as a judge, I had the privilege of working with American judges and lawyers who came to South Africa to teach trial advocacy skills to aspiring young Black lawyers. They included judges Leon Higginbottom, Nathaniel Jones, and Felton Henderson. They were outstanding role models, not only for the novice lawyers, but also for the few South African judges who were privileged to work with them. In 1984, I attended an Aspen conference for federal judges on the internationalization of human rights. The organizer was the indefatigable Alice Henkin, who arranged for 4 South African judges to attend each of 4 Aspen meetings that were held that year. Alice chose well. In 1995, all 4 of us were appointed by Nelson Mandela to South Africa's first constitutional court. The meeting that I attended in Mobile was convened in Mobile, Alabama. We were seated there in alphabetical order, and my neighbors were 2 federal circuit court judges, Anthony Kennedy and Ruth Bader Ginsburg, who remained good friends in the decades that followed. In that same year, I spent 3 months traveling the length and breadth of the United States on the United States International Visitor Program. I had the privilege of meeting with many judges, both state and federal, senior lawyers, and many leading academics. Their commitment to the rule of law and to equality was both impressive and inspiring. When I became the first chief prosecutor of the United Nations International Criminal Tribunal for the former Yugoslavia, again, it was assistance from the United States that made my very difficult task a lot less daunting. In particular, Madeleine Albright, then the US permanent representative at the UN, appointed her senior advisor, David Sheffer, to shepherd me through the bureaucratic maze in Washington, DC. I'm happy to say that David and I have remained good friends ever since. The support that the Yugoslavia Tribunal received from the United States was crucial to its success, and later to the success of the UN International Criminal Tribunal for Rwanda. Without any doubt, And without that assistance and encouragement, both tribunals would likely have foundered. Difficult and complex meetings in Washington, D.C. during 1995 led to what was a unique agreement between the Office of the Prosecutor of the Yugoslavia Tribunal and the United States government, under which the prosecutor received secret intelligence information that considerably assisted our investigations and those of my successors. That information included intercepted telephonic discussions between President Milosevic of Serbia and the self-appointed President of Republika Srpska, Radovan Karadzic. That evidence was material to the later convictions for war crimes of Karadzic and his army chief, Ratko Mladic. They are both serving sentences. The Yugoslavia Tribunal also benefited from the support it received from the Central and East European Law Initiative of the American Bar Association, CELI. Through the efforts of Mark Ellis, its founding director, the first defendant to be put on trial in The Hague, Duško Tadić, received a fair trial. Mark Ellis arranged for 2 London barristers to join the defense team of Tadić and assist his Dutch lawyer overcome his lack of experience with the art of cross-examination. Until the United Nations reluctantly agreed to pay for the 2 additional lawyers on the Tadić defense team, ABA CELI paid those costs. Mark, as many of you know, went on to become an outstanding director of the International Bar Association. I have been privileged to remain involved in some of its projects. Many mass graves were found in both Bosnia and Rwanda, in areas that were occupied by the mainly Serbian, Bosnian Serb forces. They are indeed being found today in Ukraine, in areas that were occupied by Russian forces. War criminals invariably bury the victims of their crimes, whether killings, rapes, or torture of civilians. Those graves provide what is often crucial corroboration of the evidence of eyewitnesses and victims. In Bosnia, we were concerned that the mass graves might have been booby-trapped. The UN forces then in Bosnia, UNPROFOR, refused to assist us with our work. Our requests were dismissed with the excuse that the assistance would constitute mission creep. It was a Norwegian NGO that courageously brought in sniffer dogs to look for grenades. And it was an American NGO, Physicians for Human Rights, then in Boston, now in New York, and their forensic experts who exhumed and examined the bodies. They did so also in Rwanda. Their evidence played a crucial role in some of the trials that followed in both tribunals, including the prosecution of the genocide committed near Srebrenica in Bosnia in 1995. I've remained involved with Physicians for Human Rights and have served on its board for many years. Its present work includes tracking attacks during war on medical facilities. In the first 7 months of the present war in Ukraine, Russian forces attacked no less than 233 medical facilities. Attacks on medical workers have been common in Myanmar and Syria. PHR has also been actively involved in highly successful human rights missions in Central Africa. I've had the privilege of working with 2 present leaders of ABILA, Leila Sadat and Jennifer Trahan. I met Leila when she was a very young and enthusiastic international lawyer and law teacher in St. Louis. Some years later, she invited me to be one of the members of the small steering committee she established to lead her project on an international convention on crimes against humanity. Her leadership of that project has been exceptional. The convention has now reached a difficult stalemate in the 6th Committee of the United Nations, where Russia and China are preventing that committee from reaching consensus on referring the draft convention to the General Assembly. The 6th Committee has an exceptional and arcane rule requiring its decisions to have the consensus of all members of the UN. In the end, I have no doubt that Leila, with her perseverance, will succeed in her quest to fill what is clearly a missing link in international humanitarian law. It has also been my pleasure to work with Jennifer Trahan on her project to put a stop to the use of the Security Council veto by members of the P5 in the face of resolutions to deter the commission of atrocity crimes. It's all in her excellent book, Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes. In more recent years, I've been working with senior federal district judge Mark Wolf in setting up an international civil society organization called Integrity Initiatives International, III. Its mission is to fight corruption and especially kleptocracy, leaders stealing public funds for personal gain. Our main project is the establishment of an international anti-corruption court, the IACC. The United Nations Convention Against Corruption, UNCAC, has certainly succeeded in having many states enact appropriate domestic laws to combat corruption. Too frequently, however, kleptocratic leaders subvert their own prosecutorial and justice administrations. Invariably, they launder their illicit funds in foreign countries. The amounts involved, I need hardly add, are staggering. There is no international investigative and prosecutorial mechanism to bring these criminal leaders to account and to recoup the stolen funds. Hence, the need for a mechanism at the international level. Our efforts to establish the IACC have now received strong governmental support from the Netherlands, Canada, and Ecuador. A meeting is being convened by the Dutch government at the end of next month, at which it is hoped that other invited governments will lend their support to such a court. Let me now consider briefly the somewhat inconsistent attitude of the United States government to the enforcement of the international laws prohibiting the commission of serious war crimes. Towards the end of December 2000, in the dying days of the Clinton administration, I received for David Schiffer, who had then become the first United States ambassador at large for war crimes. He informed me that President Clinton was considering the United States signing the Rome Statute. He referred to the great respect and affection that President Clinton had for President Nelson Mandela. David asked me whether I would request President Mandela to call President Clinton and urge him to sign the Rome Statute. Of course, I hastened to do so immediately, and President Mandela reaffirmed his support for the Rome Statute and undertook to make contact with President Clinton. Whether Mandela in fact spoke to Clinton, I do not know. But within days, President Clinton instructed David Schiffer to attend at the office of the Secretary General of the UN and sign the Rome Statute on behalf of the United States. Then, unfortunately, not too many weeks later, President George W. Bush instructed his Undersecretary of State for Arms Control and International Security, John Bolton, to unsign the Rome Statute. Bolton was heard to state that doing so made it the greatest day of his career, or words to that effect. In 1995, Russia and China accused the NATO powers, led by the United States, of having committed war crimes when it bombed Serbia in response to its policy of ethnically cleansing Kosovo of its Albanian citizens. The chief prosecutor of the Yugoslavia Tribunal, then Carla Del Ponte, indicated that she was prepared to investigate the role played by the NATO powers. This meant, of course, that it would potentially investigate US nationals. The United States cooperated with the Office of the Prosecutor. In the end result, Carla Del Ponte decided not to launch a full investigation into the Russian allegations. The United States accepted the authority of the ICTY, did not criticize it, and did not threaten to withdraw its support for the tribunal, but cooperated. Compare that with the response of the Trump administration when the chief prosecutor of the ICC, Fatou Bensouda, stated that alleged war crimes committed by the US in Afghanistan were to be investigated. I need hardly recall for this audience the public statements made by Secretary of State Mike Pompeo and the chairman of the National Security Council. Again, of course, it was John Bolton, excoriating the ICC. Sanctions were imposed on the chief prosecutor and a senior member of her staff. Soon after President Biden took office, the sanctions were removed. When earlier this year, Russia was justifiably accused of having committed the crime of aggression and perpetrating serious war crimes in Ukraine, the United States took the lead in calling for the prosecution of Russian leaders before the ICC for alleged war crimes. The ICC lacks jurisdiction to charge Russian leaders with the crime of aggression, and the US has also suggested support for the establishment of a special tribunal to prosecute Russian leaders for the commission of that crime, aggression. President Biden has explicitly called for Putin to be brought to justice. In short, the policies of the United States government with regard to war crimes has been inconsistent. What has remained consistent and strongly supported has been civil society in America. The American Bar Association has been a leading voice in favor of US support for the ICC. It has been my privilege to be a member of the ABA's ICC project, which was established to strengthen US ICC relations through advocacy and education, and to provide legal assistance to the court. That project has been led with great inspiration and ability by former ABA President Michael Greco. Democracy today is under siege. It is more necessary than at any time in the recent past for the United States to assert its leadership as the leading democracy in the world. Too many democracies have veered towards autocracy. Think of Hungary, India, Brazil. The Trump administration had scant respect for the rule of law. There are others. Today there is a lurch to the right in Sweden and in Italy. Freedom and civil rights have been snuffed out in Afghanistan and Myanmar. I know that I need not convince you who are attending this International Law Weekend, of the importance of democratic rule and the observance of the rule of law. What is insufficiently recognized and acknowledged is that the example set by the United States is followed in other parts of the world by both democratic and autocratic leaders. Trump's unfortunate actions were cited as justification for autocratic actions and policies in many parts of the world. It was said by autocratic leaders that if the United States could ignore the results of free and fair elections, why not the same, for example, in Brazil, as has been suggested by President Bolsonaro? Kenya, fortunately, was just spared that fate when the decision of its Supreme Court that the elections were free and fair was accepted by the loser, Raila Odinga. The responsibility of the United States to support democracy and the rule of law has never been more important. The resolve of those who support democracy has never been more crucial. Your example has been as important and crucial as it has been steadfast. That you will continue to stand strong, I have no doubt. Thank you again for honoring me.
Yeah. Richard, I don't know if you have your plaque handy.
Can you see us, Richard?
Do you have your plaque handy? Can you possibly, so we had to mail. There it is. Yay.